All right, so let's go over Unit 38. Talk about Arizona Residential Landlord and Tenant Act. In this unit, we're going to go over the unit overview. In Arizona, residential rentals are regulated by the Arizona Residential Landlord and Tenant Act. This unit looks closely at the important details of this statute. Licensees who provide property management services for their clients should read and reread this statute to be able to serve their tenant and landlord clients in a highly professional manner. We're going to go over these topics. So, Arizona Landlord and Tenant Act exceptions, the landlord obligations, tenant obligations, notice to tenant before entering, self-help for minor defects, prohibition against distraint, evictions, bed bug control, short-term and vacation rentals. So those are the topics we're going to go over in this chapter or this unit. And then after completing the unit, you're going to be able to list the properties that are exempt from the LTA, discuss security deposit requirements, explain the difference between deposits and fees, discuss security deposits, accounting, at lease termination, recite landlord disclosure requirements, list the obligation of tenants, explain notice requirements before entering a living unit, list tenant options for landlord non-compliance, discuss a tenant's options when landlord does not take action to repair minor defects, state requirements to terminate a month-to-month tenancy, state the time period to begin an eviction for failure to pay rent, define abandonment and discuss the parties' rights relating to personal property left in the premises. You'll be able to define distraint, list the parties' obligations relating to bed bugs, explain the requirements relating to short-term and vacation rentals. Okay, so you're going to need to do some independent studying. I'll go over the unit summary and the unit quiz. Okay, so these are the key points. So before moving on to the unit quiz, please review these key points. So the LTA does not apply to commercial properties, hotels and motels, religious service housing, school, dormitories, and public housing. Right, so LTA doesn't apply to those. LTA prohibits discrimination against tenants with children unless the property has a valid restrictive covenant against it in which it prohibits children. Landlords may not require security deposits, including prepaid rent or deposits, in excess of 1.5 months' rent. If not stated as non-refundable, deposits are considered refundable. So again, if not stated as non-refundable, deposits are considered refundable. So you have to actually state, so if you put in a deposit and it wasn't stated as non-refundable, it typically is refundable. To apply security deposits to damage and or rent, the landlord must give the tenant a statement of amount due within 14 business days. It's about 2 weeks. So the landlord is subject to 2 times amount of the security deposit as damages for non-compliance. At lease inception, the landlord must give tenants a signed copy of the lease, a move-in form for tenants to note existing damage, and a written notice that tenant may be present at move-out inspection. Separate non-refundable fees may be required above the security deposit. The landlord must disclose the person authorized to manage premises, owner or owner's agent for purpose of service of process. A free copy of the Landlord-Tenant Act is available from the Arizona Department of Housing. The landlord must comply with health, safety, and building codes, keep premises fit, habitable, and safe, maintain mechanical equipment in working order, provide trash receptacles and trash removal, providing running hot and cold water and heat and air conditioning when required by seasonal weather. The tenant obligations, right? They are to use the premises in a safe manner, keep the premises clean, use mechanical equipment in a reasonable manner, not deliberately or negligibly destroy or deface the premises, conduct themselves as not to disturb a neighbor's quiet enjoyment, follow rules and regulations established by the landlord for all tenants' welfare, except in emergencies and unless waived by the tenant, the landlord must give the tenant 2 days notice to enter the premises. So can the landlord enter into your premises? Yes, they can if they give you 2 days notice, minimum. If there is a non-compliance by the landlord, the tenant may deliver notice to terminate the lease within 5 days for breaches affecting health and safety, 10 days for other breaches. For minor defects that the landlord does not promptly repair, the tenant may hire a licensed contractor so long as the reasonable cost of the repairs does not exceed $300 or half of the monthly rent, whichever is greater. So, sometimes if the landlord doesn't upkeep with some of the items, then the tenant can actually hire a licensed contractor. But if they don't pay that licensed contractor, can the licensed contractor put a mechanic's lien on the property? No. It has to have come from the actual homeowner. The licensed contractor can only put a mechanic's lien, on the leasehold. Right. A month-to-month tenancy may be terminated by either party giving notice to the other at least 30 days prior to the periodic rental date specified in the notice. The landlord may begin an eviction after 5 days if the tenant fails to pay rent. So, if you're the landlord, you're renting to a tenant, and it's due on the 10th, right? And they don't pay 5 days later, you can start the eviction process, right? If they miss 5 days, it's their responsibility, right, to pay you. So, if the tenant abandons the premises, the landlord must send a tenant notice of abandonment and post the notice on the dwelling door for 5 days before entering the unit. So say they just, up and cut and leave the premises, you need to put a note on that door, giving them a notice, right? And you have to leave there 5 days before you enter. So is it 2 days minimum? No, it's 5 days now, right? Because if they abandoned it. Landlord must hold personal property for at least 14 days before disposing of it. So say they don't, rent comes due, they don't pay for 5 days. You put a notice, and then you go in their house, and then there's a bunch of stuff. So you start the eviction process. They're evicted, right? So now say it's like the 10th day. Can you take all their stuff and throw it away? No. You have to hold it for how long? 2 weeks, about 14 calendar days, right? 14 days. Landlord may begin an eviction after 5 days if the tenant fails to pay rent. A tenant may terminate a lease without penalty if the tenant is a victim of domestic violence. So if you're getting violent in the unit and you're renting from your spouse, right? Girlfriend, boyfriend. Can they terminate the lease without a penalty? Yes. If it's related, if it's domestic violence, right? Boyfriend, girlfriend, they're in a relationship. You don't have to pay a penalty. Terminating the lease. Distraint, holding a residential tenant's personal property for back rent is illegal. So it's called distraint, holding a residential tenant's personal property. So, say they don't pay. Say they don't pay. I've heard stories that, landlord, oh, this PlayStation 5 is mine now. No. Just because they can't pay, you can't take their personal property. That's illegal. You can go to jail. So you don't do that. Now, can you hold their deposit? Sure. That's what the deposit is there for. But their personal property, say like a PlayStation 5 or some of their clothes, you can't claim any of that. Regarding bed bugs, the landlord shall not lease a property known to have current bed bug infestation. So if the landlord knows there's bed bugs in the area and it's not clean and they want to rent it out, they rent to somebody, can they do that? No. Bed bugs have to be cleaned out before, so they cannot rent to someone knowing that there was bed bugs. A current bed bug infestation. Landlord must provide educational materials to tenant. A tenant shall not knowingly move in materials that are infested with bed bugs. So again, if the tenant knew that there was bed bugs, they shouldn't. They shall not move in like a bed that had bed bugs. A tenant who knows the presence of bed bugs must notify the landlord. Single-family residences are excluded from the bed bug laws. So, this really applies to apartment complexes because usually an apartment complex is kind of rampant with bed bugs for some reason. But for single-family homes, do the bed bugs laws apply? No, they don't. So if you're renting a room or something like that, bed bug law doesn't apply. A city, town, or county may not prohibit short-term rentals or vacation rentals. A vacation rental or short-term rental may be used for non-residential uses. Vacation rental owners must provide local government with local information for responding to complaints. Vacation and short-term rental owners and operators must obtain a sales tax license. So again, vacation and short-term rental owners and operators must obtain a sales tax license. And this is if you're renting out the whole space versus like renting out a room. A finder fee may be paid to a tenant in an apartment complex if it is paid as rent or rent reduction. So can you take cash? No. You have to pay it out. Say a tenant, and it only applies to apartment complexes. So does it apply to single-family homes? No. This rule only applies to apartment complexes. So if you want to be a property manager from an apartment complex, this is something you need to really remember. So if one of the tenants refers a person to live there, you can pay that tenant a rent credit or a rent reduction, but you cannot pay them cash. No more than $500, no. Pay no more than once a year, no. Paid as a rent credit, yes. No more than $200 cash, no. If the landlord fails to deliver possession of the unit to the tenant, which of the following actions could the tenant elect to exercise? A. After 5 days, the tenant can terminate the lease. After 5 days, the tenant can terminate the lease. So if the landlord fails to deliver possession of the unit, to the tenant, right? If the landlord fails to deliver possession of the unit to the tenant, which of the following actions could the tenant elect to exercise? After 5 days, the tenant could terminate the lease. Right, so they could just terminate it without any penalty. because the landlord didn't return the unit back to the tenant. Tenant would be entitled to the return of all deposits plus 6 months rent. No. Tenant could demand and receive 1 year's rent free. No. Tenant will be entitled to 3 times the deposit as damages. No. Distraint is defined as Bravo, placing a lien on a tenant's personal property to collect back rent. So distraint, right? So what does distraint mean? Distraint means you place a lien, right? Probably judicial, right? You go to a judge, go to court order, placing a lien on a tenant's personal property to collect back rent. That's a distraint. Distraint, you're putting a lien on personal property. Is it evicting tenant? No. The right of quiet enjoyment? No. Restraining a landlord from evicting a tenant? No. Can exercise the self-help for minor defect provision. The tenant must give the owner how many days to cure the defect. Delta 10, right? 10 days. So tenant has to give landlord 10 days, right? Before a tenant can exercise self-help for a minor defect provision, tenant must give the owner 10 days to cure the defect. Regarding the short-term vacation rentals, all the following are true except what? C, the online lodging marketplace must be owned by the online lodging operator. So that is not true. A city or county may not prohibit them. True. They may not be used for non-residential uses, such as special event that would require permit. True. Online lodging operators must attain a transaction privilege tax license. True. The online lodging marketplace must be owned by the only online lodging operator. That is not true. What is a violation of the Residential Landlord and Tenant Act? Alpha, asking for first and last month's rent plus 1.5 months rent as security deposit without tenant's approval. So asking for first and last month rent plus 1.5, so first and last month's rent plus 1.5 months rent as security deposit without tenant's approval. So that's a violation of Residential Landlord and Tenant Act. So asking for a non-refundable pet deposit, that's fine. That's not a violation. Returning security deposit to the tenant within 14 days after the lease termination, that's fine. Asking for a non-refundable cleaning fee, regardless of property condition, that is fine. A forcible entry and detainer would be an action taken by which of the following parties? Delta, the lessor. A forcible entry and detainer would be an action taken by which of the following parties? The lessor, right? So the lessor would be an action taken by the lessor, right? You got the lessor renting to the lessee, right? So the lessor would take that action. They would have a forcible entry and detainer, right? So is the mortgagor, mortgagee, no. Vendor, no. The Arizona Residential Landlord and Tenant Act established Delta landlord and tenant obligation. Landlord and tenant obligation. So this is the Arizona Residential Landlord and Tenant Act, right? That established the landlord and tenant's obligation. What's the landlord obligated to do? What's the tenant obligated to do? This is the Arizona Residential Landlord and Tenant Act. Did they establish max rents for residential apartments? No. Base rents for commercial retail? No. Real estate brokers' responsibilities? No. It established landlord and tenant obligations. Under the Arizona Landlord and Tenant Act, the tenant would be able to terminate a lease without penalty if the if the tenant was the victim of domestic violence. So under the Arizona Landlord and Tenant Act, the tenant would be able to terminate a lease without penalty if the tenant was the victim of domestic violence. So again, you can always terminate a lease if you're renting with if you have a relationship with a domestic partner. You can end that lease if there's domestic violence, and you don't have to pay the penalty. Right? Any type of domestic violence, you can always end the lease without any penalty. If the landlord received at least 10-day notice, no. Tenant has lived in the property for more than 1 year, no. Tenant purchased a home in the state, no. The laws relating to bedbug infestation in rental property apply to all of the following property types except a Delta single family residence. Single family residence. So the laws relating to bedbug infestation in rental property apply to all the following except single family residence. So do bedbug laws apply to single family residents? No. It's mainly for apartment buildings. So a apartment building, yes. Owner occupied fourplex, right? A fourplex, still sort of the apartment building. So yeah, condo complex, yes. So condominium complex, owner occupied fourplex, apartment building, those are all within the same realm, but it does not, the bedbug law infestation does not apply to single family residents. If a tenant abandons a residential apartment, the landlord must do all of the following except what? Except sell the tenant's personal property after holding it for 10 days. So sell the tenant's personal property after holding it for 10 days. So if a tenant abandons a residential apartment, the landlord must do all the following except that one. Except sell the tenant's personal property after holding it for 10 days. How long do you have to hold it? 14 days. Right? So D's wrong. So A, well, D's correct, but it's not what you're supposed to do. A, send a notice of abandonment to the tenant through certified mail. Yes. Post a notice of abandonment on the apartment door and wait for 5 days before entering. Yes. Hold any personal property of the tenant for at least 14 days before disposing of it. Yes. A landlord of a residential property must give the tenant all the following except, bravo, copy of the Landlord and Tenant Act. Copy of the Landlord and Tenant Act. A landlord of residential property must give the tenant all the following except that. You don't have to give them a copy of the Landlord and Tenant Act. What you do have to give them, you got to give them a signed copy of the lease, right? They got to know what they're signing. Move-in form for tenant to note damage, and a written notice allowing tenant to be present at move-out inspection. So it's called a written notice allowing the tenant to be present at the move-out inspection. When a tenant causes a material breach in the lease, the owner may issue a formal notice that states the lease will terminate in 10 days if the matter is not corrected within 10 days. Lease will terminate in 10 days if the matter is not corrected within 10 days. When a tenant causes a material breach in the lease, the owner may issue a formal notice that states lease will terminate in 10 days if the matter is not corrected within 10 days. So lease will terminate in 10 days if the matter is not corrected within 14 days? No. Lease will terminate within 10 days if the matter is not corrected within 5 days? No. The lease will terminate in 5 days if the matter is not corrected in 10 days? No. A tenant The tenant gives notice of hazardous material on their property to the landlord. Within how many days must the landlord take action to cure the problem before the tenant can terminate the lease? A alpha 5 days. So it's got 5 days. So tenant gives notice of hazardous material on their property to the landlord. Within 5 days, how many days? 5 days must the landlord take action to cure the problem before the tenant can terminate the lease. So tenant gives notice of hazardous material on their property. So hazardous material, could be all kinds of things. But landlord has 5 days to cure the notice of hazardous material. So 7, 10, 14, no. When a tenant does not pay the monthly rent, the landlord first step would be to, bravo, send a 5-day notice for non-payment of rent. Send a 5-day notice for non-payment of rent. So when a tenant does not pay the monthly rent, the landlord's first step would be to send a 5-day notice for non-payment of pay the monthly rent. The landlord's first step would be to, bravo, send a 5-day notice for non-payment of rent. Send a 5-day notice for non-payment of rent. So when a tenant does not pay the monthly rent, landlord should send a 5-day notice for non-payment of rent. So, just write an email or text saying, hey, it's been 5 days. This is a notice. This is your 5-day notice of non-payment of rent. Should you file a lawsuit in justice court? No. In a rental that is located in an extreme climate environment, the tenant must give the landlord 5 days to repair the unit. Must give the landlord 5 days to repair the unit. So the air conditioning goes out in a rental unit that's located in an extreme climate environment like Arizona, right? The AC goes out. The tenant has to give the landlord at least 5 days. So this is an example that's happened to me, right? My AC went out. I had renters, and the next day I was on the ball, got the new units, installed it, fine. But the tenants have to give the landlord 5 days to repair the unit. Can they immediately purchase a wall unit and deduct the cost from the monthly rent? No. Can they terminate the lease? No. Can they move into a hotel at the owner's expense until the unit is fixed? No. Number 20, in order to terminate a month-to-month lease, a person will be required to give Delta 30 days notice. 30 days notice. So in order to terminate a month-to-month lease, a person would be required to give 30 days notice. So again, 10 days notice, 14, 21, no. So, it goes both ways. Landlord gives 30-day notice when they want to evict somebody. And then also the tenant needs to give 30-day notice when they want to move out. Right? You can't just move out the next day just because you're mad. No, you want to always give a 30-day notice when you're ready to move out in real estate. Okay, next we're going to go to Unit 39, talk about property management and planned communities.